The joint Republican-Democrat caucus is called to order. I want to thank you all for being here. We're going to jump in just a moment. The purpose of this is either to educate or re-educate us on a lot of different topics. Obviously, the issue of sexism and sexual harassment has come up recently, but it goes beyond that. It goes into quid pro quo. It goes into what impugning means, a lot of issues that we've faced over the last year. So I appreciate the staff and others who are here to talk about these various topics. It's a full agenda. My request of you is ask questions. Ask questions. There are no stupid questions. This is an opportunity for us to get clarity where we maybe need clarity to better understand these topics. So please ask questions, or I'll start asking lots of questions. I've heard lots of questions from you all over the last few months, so I know they're out there. And this is the opportunity to ask them of our experts here. To do that, just press your request to speak button as you would with any issue, and I'll see you and I'll call on you. So we'll still handle this like the normal protocol of going through the chair, although we're not in session officially. So hopefully all of you have a copy of this booklet here. I know there's a lot of information, but most importantly, if you look on the first page, you can see that there's essentially an outline of what we're going to be covering. And then this is something for you to keep and use as a resource. I know there's a lot here, though, so never be afraid to ask questions, even beyond today, especially of our attorneys and our staff. Before we get started, are there any specific questions of me from any of you about what we're doing or why we're doing it? Okay. Then before we get started, I'm going to call on Mr. Shooter.
Thank you, Mr. Speaker. Members, I know you all want to thank me for my part in bringing you here today, but I wanted to read a statement that I have prepared. I'm going to try to read it and not go off script. So, our legislative community is currently going through an intense period of self-evaluation on the topic of how we treat each other, where we've been failing to do things right, and how we need to do things better. My own involvement in all this has been greatly magnified as a result of a complaint that was filed against me for reasons that I believe are largely unrelated to the complaint itself. However, the complaint was followed by a number of additional complaints, the majority of which were sincere, and which exposed me to the knowledge that my actions were not always received as intended, and that worse still, they caused genuine discomfiture or pain. At first, my response was largely defensive, born of frustration, and a few complaints were not true or made for personal or political vendettas. But it would be a mistake to treat each and every complaint the same if I failed to learn from legitimate complaints, and if I failed to recognize and apologize for those actions that caused damage or hurt. We, as a larger capital community, cannot begin to heal until those of us who have made mistakes begin the process ourselves. For me, that means learning and changing, so I stand before you today because it is my desire that we now begin to heal. Excuse me. The healing won't start in earnest, at least with respect to the people who I've hurt, without me recognizing that comments that I have made in jest over the past 7 years were not received in the spirit to which they were intended, or quite the contrary, some were jarring, insensitive, and demeaning. I don't need to wait for an investigative report to know that. In the past, when I've told a joke that landed badly, I realized it, and I always apologized. My purpose is always to entertain and get people smiling and laughing, and that has been my style as a kid, a farmer, a legislator. When someone reacts badly or tells me I've hurt their feelings, I feel terrible and try to immediately remedy it. It has been hard to sit on my hands during this political and legal process and not acknowledge that I care. I want to get it right, and I want to make it right. I was beyond embarrassed to hear that what I thought were welcomed and well-intentioned hugs were perceived as creepy and lecherous. I didn't know. As soon as I did know, I have been and I am sorry. I will confess that were times when hearing that I had offended someone with a boorish comment or that what I had intended as a simple hug turned into someone believing that I had crossed some line. I was sorry. But I also reacted defensively and thought to myself that some people are just too sensitive. It has taken me time to understand that I have been insensitive. It is unfair to expect everyone to react to things the way I might react. And if I'm going to be a comedian, I have to understand and be sensitive to my audience, not blame them when my jokes fall short. I know that comments intended to be hospitable, harmlessly flirtatious and outrageous, and above all intended to be humorous weren't at all humorous and caused others to believe that I did not value who they were as individuals. I've taken all this very hard. I have a stupid flu. I've taken this very hard, and those who know me well know that under all the clowning and the shtick I put on, I care a lot. Nor was this reaction limited to how women reacted to my behavior. During this investigation process, I learned that I not only offended women, one complaint was from a man. I learned that a crass and offensive comment I made in jest in an after-hours event to a legislative candidate in response to a political prediction was perceived as sexual harassment, which I never would have imagined. My sarcastic response related to buggery. Repeating my response now during the day in front of my colleagues, including women, is evidence enough that I should not have said it. It is a little rough. This candidate interpreted my remarks as serious, not sarcastic, for which I am embarrassed and deeply regretful. I look forward to apologizing personally. It is important that you all know that while my actions have unintentionally offended some, I have never attempted to touch anyone, make obscene gestures to a woman, or sought a tryst or sexual relationship. It may be inconsistent with my attempts at humor, but I have lived my life as someone who absolutely reveres and respects women. I have been blessed to be married for 41 years to an incredible woman to whom I have remained devoted. I was brought up to be a gentleman who will hold the door, pull out the chair, stand when a woman leaves the table, lend her my jacket when she is cold. However, I am now acutely aware that not everyone understands my attempts at humor and resented that I did not show the respect and value each individual deserves. This is one of the things that bothers me the most. I am sorry. I'm sorry for the distraction and strain that this matter and the subsequent investigation have caused all of you. That was not my intent when I asked for the investigation. I don't want to go one more day without apologizing and honoring all of you, not only by saying I'm sorry, but by doing better. This has been a painful process for all of us. Hopefully, to you, those of you I've hurt, you feel empowered for speaking up. Your courage has already had a profound impact on the way I relate to others. I also want to tell you that I am still your friend and want to hear from you. I especially want to hear if I'm doing something wrong. I wish that, I've heard a little bit of that. I wish that the people who came forward months or years later had said something immediately at the time so I could have apologized and made improvements along the way. But I understand why they didn't. I hope that while I strive to be better, you would help me all along the way, and if you see things that I can improve, it's time to repair and begin to heal. I want to get this right. It can be tough to teach old dogs new tricks, but this old dog can learn and will do better. I look forward to personally listening, expressing my remorse once the investigation is over, to the extent of those I have offended are interested. I'm sorry. Thanks.
Okay, we're going to go ahead and get started. Tim, why don't you take it away?
And thank you, Mr. Speaker, members. Good morning. Welcome to the PSOP training we have for everyone this morning. A word of welcome to each one of you. I think each one of you have already attended this training at least on 1 or 2 or maybe 3 or even 4 occasions in the past. But we want to take a moment to try and just reawaken an interest in this issue and to revisit topics. We can always learn something from going over materials. And as the speaker mentioned, each one of you should have received a copy of the most up-to-date version of the PSOP manual. And PSOP means Public Service Orientation Program. We commonly refer to it as the ethics training portion. Can everyone hear me okay? Can everyone hear me okay? I'll get a little closer. Is that better? That's worse. That's worse. Oh, how about that? Sorta? Okay, thank you very much. And let me know if you can't hear what I'm saying or if you can't understand me, just holler out and I'll try to slow down or clarify a little bit, maybe get a little farther away from the microphone. So, is that better? All right. Very good. So you can hear me a little better, and I can hear you and see you all. Thank you. So when you look at this material that you have before you, as the speaker mentioned, it's our hope that you'll keep this book. This is a great resource material for you, and a reference material for you. So on the very first page, you'll see basically the outline of the event today, the agenda for what we're going to do, and just to kind of go over the big picture issues. First, we're going to have the segment involving the workplace harassment prevention issues, and we're going to have a guest speaker. We do have a guest speaker from the Attorney General's office, who I'll introduce in just a moment. Then we're going to go through other staff is going to lead you through the appropriate conduct of business part of it, things having to do with bribery and things having to do with disorderly behavior and expulsion. I just would like to kind of go over the highlight of the things that I'd like to just make mention of in terms of reference materials for you, and then we're going to drill down into it a little bit more in just a moment. But before I get into those issues, I'll go ahead and just at this point begin with turning it over to Rebecca from the Attorney General's office, who can introduce herself. One thing I'd like to make a comment about before I do that, though, is that the issue of ethics training came about here starting in about 1992 in a more formal way that we have now with regard to the law that requires public service orientation training, ethics training. And the issue about ethics is teaching ethics is one of those issues where people say, well, you can't really teach ethics. Ethics is either something that you have or you don't have. And I will tell you that I disagree. We can teach ethics, and that's what we're going to do today. And we have taught ethics, and we will continue to teach ethics. Whether individuals choose to avail themselves of the training and the understanding of what's required to act ethically is a different issue. But teaching ethics is very important. One of the things that we're going to try to address some answers to practical questions that you may have. And so a couple of examples of frequently asked questions that we hope that you'll be able to have answers to after this training or as part of this training are, what do I do if someone's acting creepy and they won't leave me alone? That's the workplace harassment part. What can be done to prevent public corruption? There's a big segment about that. Is it okay to have lunch with a lobbyist? What about lunches outside? Can I attend those lunches? Can I accept gifts? If so, what are the rules about accepting gifts, and how does all that work? Another question, do I really have to keep a secret that somebody tells me? Sometimes you might have a situation develop where, as we're heading into the election cycle, your staff or you might receive a call while you're here about a campaign contribution. What should you do? If a lobbyist gives me tickets to the Phoenix Open, can I go? There's a lot of detail and intricacies to the answer to that question that Mr. Drake's going to address for you in just a little while. Is it okay to ask an intern out for drinks? That's a good question. So let's get started, and let me go ahead and introduce then once again Rebecca Browder, and Rebecca is the Section Chief of the Civil Rights Division at the Attorney General's Office, and thank you very much.
Thank you. Good morning. Can everyone hear me okay? Great. My name is Rebecca Browder. I'm Section Chief of the Civil Rights Division at the Arizona Attorney General's Office. I want to say that views here are not expressed official opinions of the Arizona Attorney General. So let's get started. Our course goal today, and I'll be speaking to you for about 30 or so minutes. What is expected of you? The state of Arizona expects high ethical standards from all employees, which includes a respectful and professional conduct with each other and the public in general. We're going to look at what is unlawful conduct. We're going to look at what should you do if you face harassment, and the process to file a complaint and the procedures after filing. Of course, this course focuses on unlawful conduct, but our standards are higher than that. Professionalism. What does this word mean to you? It is more than just competence. It's about commitment, communication, demeanor, and image. The importance of this is that work should be a safe place. And I want to say that my presentation is on page 98 in your booklets. It starts there if you're interested. I think most of the slides are in there, although there might be a couple missing because they were created a while ago. The importance is that work should be a safe place. Our environment should be one where everyone is valued regardless of background. And I'm sure we all understand and know that productivity is enhanced when drama in the workplace is reduced. What's the solution? Respect and treat everyone you would want to be respected and treated in the workplace. Respect and treat everyone the way that you would want your spouse, your child, or your parent to be treated in the workplace. And I am a mom of one-year-old twins, so I have to throw them in the slide at least once. There might be a picture later. But when I picture a workplace environment, I picture where I would want my son or my daughter to be working and what kind of environment I would want them to feel and feel going to a workplace. And that would be a safe environment free of discrimination. These are a list of the relevant state and federal laws, although this is not a comprehensive list of employment laws. We're going to be focusing mainly on the U.S. Civil Rights Act of 1964, also referred to as Title VII, and then of course the Arizona Civil Rights Act, which the Attorney General's Office investigates and litigates cases in those areas. And this is not a list of all employment laws. So what is unlawful discrimination? Unlawful employment discrimination means that the employee or an applicant to become an employee is treated unfavorably because of that person's membership in a protected class. And we're going to go over what a protected class is in the next slide. But employment decisions that are based on a protected class interfere with equal employment opportunities. What are protected classes? Race, color, religion, sex or gender, pregnancy, national origin, age, and for employment, it's above age 40, disability, military or veteran status, genetic information, and I've included sexual harassment here, or sexual orientation here, because some federal circuit courts have recognized sexual orientation as a protected class. Title VII. What does Title VII require? That employers do not discriminate against an individual on the basis of race, color, sex, national origin, religion, protected classes, with respect to hiring, discharge, compensation, promotion, classification, training, apprenticeship, referral for employment, or any other, what can be considered any other terms, conditions, or privileges of employment. In short, employees should be provided equal opportunities that are not based on a protected class status. How do we do this? We make every employment decision based on a legitimate business purpose related to the employer's mission. So what is unlawful harassment? We're going to look at quid pro quo harassment and then hostile work environment based on any protected class. And we're going to look at economic and environmental areas. Economic harassment usually involves money. It involves a supervisor, an abusive power position, involves a tangible employment action, we'll discuss what that is, and involves threats or promises. So the idea is that you cannot create environmental harassment for your coworker. This is conduct of a sexual nature or conduct directed at a protected category. It must be unwelcome. It has to be, the courts look at offensive to the receiver, the person who is being harassed, and also a reasonable person. We're going to go through what that means. It can be severe, which is a one-time incident. It can be pervasive, which means it keeps happening over and over again. And this type of harassment occurs when there is unwelcome conduct that unreasonably interferes with an individual's job performance or creates a hostile, intimidating, hostile, or offensive work environment. So what is sexual harassment under this definition? Based on gender, unwelcomed conduct that is sufficiently severe or pervasive to alter the conditions of employment and create an abusive work environment. Again, we look at it is offensive to the victim, and we also look at it is offensive to a reasonable person similarly situated to the victim. How do we tell if conduct is unwelcome? It has to be, again, subjective and objective. We need to pay attention to the responses of others. No means no. Maybe means no. The verbal response and the nonverbal response of the person. We look at expression changes and we look at body language. We're going to look at types of conduct that can create a hostile work environment. Physical conduct, verbal conduct, and visual conduct. Examples of physical conduct that can create a hostile work environment. Sexual activity, blocking a person when they're trying to walk through a walkway, hugging, massaging, and of course, assault. Bottom line is we need to be sensitive to a person's individual space. Examples of verbal conduct that can create a hostile work environment. Telling offensive jokes, stories, epithets about a protective category or stereotyping. Swearing or usually using words with sexual connotations. Repeatedly asking for a date after rejections or making unwanted sexual advances. Asking intrusive questions about the other person's personal life, whether it's dating, their race, religion, etc. Expressing opinions about another's religion. Talking about your own personal sex life, or grunts and moans. Examples of visual conduct that can go to creating a hostile work environment. Offensive posters, cartoons, or pictures. Offensive text messages or emails. Leering, staring, or winking. Looking a person up and down. And offensive gestures with hand or body movements. There is no magical line to determine what is and what is not sexual harassment or unlawful harassment. At the Arizona Civil Rights Division and the EEOC, we look at the totality of the circumstances about what's going on. What is happening at the time? What is the nature of the contact? Is it the conduct offensive to the person receiving it? Is the conduct offensive to a reasonable person? Is this reasonable behavior? Is this severe? Is it repeated behavior which goes to pervasiveness? Bottom line, be professional, be respectful. We're going to go through a few scenarios and feel free to audibly answer. It's always nice to have audience kind of buying into the, so we're going to look at a female employee asks a male employee to dinner and he declines. Is this sexual harassment? I hear some no's. Correct. Asking a person out isn't necessarily sexual harassment. What if it makes the male employee so uncomfortable that it affects his performance at work? Does that mean it's sexual harassment? Don't really hear anything. So again, we look at reasonable, objective, and subjective. If it is, we look at the totality of the circumstances, and if it is offensive to him and also a person reasonably situated to him, it could be sexual harassment. What if she asks him daily and he declines daily? Is that sexual harassment? Lots of yeses there, absolutely. It becomes a part of his job. It becomes an expectation, changes his terms and conditions of his employment. What if she is his supervisor and promises him a raise if he goes to dinner with her? Is that sexual harassment? Yes, that's what we call quid pro quo sexual harassment. So what is the best practice in this situation? I would say that the best practice is probably not to date anybody at work. And if you choose to date someone at work or date someone you're working with, just make sure or ask them out. Keep in mind what we looked at unwelcomeness. No means no, and maybe means no, and leave it there. Is this sexual harassment? Scenario number 2. A female employee touches a female employee's thigh while making a remark about sex. I see some yeses, I hear some yeses. Correct. That is absolutely right. It is sexual harassment. But and the question is, can sexual harassment involve people of the same gender? Justice Scalia wrote the opinion in Oncoli versus Sundowner Offshore Services is a 1998 opinion by the Supreme Court. Justice Scalia wrote that harassing conduct between members of the same gender may constitute illegal sexual harassment. Can one incident be severe enough that it need not be pervasive? Yes, it can be severe enough. Again, we look at severe or pervasive when we look at whether or not it's a hostile work environment sexual harassment. What if the conduct is in jest and welcomed? Is that sexual harassment? I think I heard a no, and that's correct. It is not sexual harassment for the person that is being touched and the joke is made. However, because with sexual harassment, it has to be unwelcome. However, a person that did that, the female employee who did the touching, could potentially create a hostile work environment for someone who did not know it was in jest and did not know it was welcome. And that could go to a sexual harassment or an environment for another person who observed it that didn't know those two things, and might think that it's part of their job to allow this female to touch their thigh and make remarks about sex. So what is the best practice? Of course, don't make jokes about sex or sexual connotations, and don't touch other people at work. Scenario number 3. A male employee says to a female employee, "Gosh, it's great that you've entered the workforce, but wouldn't you rather be a stay-at-home mom?" Can sexual harassment be based strictly on gender? Absolutely. What if nothing about the context seems sexual? It's not a sexual joke, there's no touching. Can that be sexual harassment? Yes. So another Supreme Court case decided May 1989, May 1st, is that it's called Price Waterhouse versus Hopkins. And that discusses sexual stereotyping. So I would argue that this is a stereotype about women, that they should be stay-at-home moms if they have kids at home. So it can actually go to hostile work environment. What if the conduct is in jest? What if it's a joke? Can that also still be sexual harassment? And if it's unwelcome, the answer is yes. So what is the best practice? Again, we go back to just not making inappropriate jokes at work. Sexual harassment scenario 4. A male employee says to a female employee, "How is it that you are as old as you are?" Oh, question?
Mr. Bowers.
I apologize for tardiness. We need to go back to, you ended scenario of the unwelcome touching of equal gender people with a comment that it's best not to touch another person at work. And I could think of thousands of, I saw it just today. So exactly, in my mind, I think, how far does that go? How far does that counsel go? Are we talking about shaking hands? Are we talking about touching a shoulder? Are we a pat? How far does that go? And is it always in the context of a perceived touching in the context of a comment about sex?
So I would say it depends on a one-to-one basis. If you meet somebody and you know them and you give them a hug, or if you shake hands when you're meeting somebody, I would say that that's certainly a court would look at in totality of the circumstances. If you're just meeting someone and you shake their hand, I was saying more, and perhaps I was a bit unclear, that sexual touching is never appropriate at work. Does that answer your question?
Thank you, yes.
Ms. Powers-Handley.
Yes. Thank you, Mr. Speaker. I rise to ask a question.
Go ahead.
So, yes, regarding jest, I've had this happen to me several times, not here and not by anybody here, but outside, where I will take issue with a comment and call the person out, and then they say, oh, it was just a joke. And so it's like brushed off when I take issue with it. And so how would you handle that sort of a situation? Because it's obviously not initially said as a joke.
So for an employee-employer relationship, or just the house?
Just in general.
And so I would look at, if an employer, if a manager said a joke to their employee, and it was a racist joke or a sexist joke, that could certainly go to hostile work environment if there were other totality of the circumstances areas to look at. Did that answer your question?
I guess my comment is more like something is said and not necessarily said as a joke, but then when a woman would take issue with it, it's brushed off as a joke. I was just kidding, you know, no offense intended, or I don't know. It just happens repeatedly, it seems.
Sexual harassment has to be unwelcome, and if that is an unwelcome, or hostile work environment, unwelcome. So it has to be an unwelcome thing that is said.
All right, thank you.
You're welcome.
Ms. Epstein.
Thank you for asking a question, Representative Bowers. I would like to share a couple of thoughts, since we're talking about touching, about what people may or may not want. For instance, I am short and round and apparently teddy bear-like, and I do not necessarily want you to throw your arms around me when we take a photo, gentlemen. I think that it's just like everything else. Ask. You know, I love to hug, but I will ask, can I give you a hug? Do you want a hug? Don't assume it. And then I also will frequently touch somebody's arm to get their attention, or just to express I care about what you're saying. But I generally like to know that we've already established some kind of contact before I do that. In AYSO, we teach a lot of basics, how to touch and not touch. And one of the rules is let the other person initiate it. And so with women, gentlemen, that may be your best guideline. Let the other person initiate it. Or ask. Just outright ask, may I touch your shoulder? Because that's another thing, that women don't necessarily want you to touch their shoulder. Mr. Cook, may I touch your shoulder? Whereas Mr. Cook may find this to be just a fine thing, a woman may not, and another man may not. So it is just fine to ask each other, may I touch your shoulder? It's something that can be found a little aggressive. So I really would like to invite all of you to think twice. And again, I've worked with some organizations where we work with hugging and touching and all of that a lot, because sports are contact. And so we've had to go through this, and I've taught an awful lot of safety training and to an awful lot of men coaches. So ask and don't assume any kind of touching is going to be accepted or wanted. They may just be being very quiet about it. So if today means you start to think twice, and thank you, Mr. Schroeder, so much for your very thoughtful response and openness to learning these different perceptions. What you thought was fine might not be fine. So ask, literally say, may I touch your shoulder? May I give you a hug? And then you'll know. Thank you.
Thank you. Mr. Lawrence.
Mr. Speaker, in the past 2 days, I have probably been hugged or hugged 30 or more times in the past 2 days. It is a regular feature of my life. Can someone who sees this be offended enough by it, not the individual, none of the individuals, nor have I, been offended? Can someone seeing that be offended by it and report it as a form of harassment?
Don't look at me.
Okay. I didn't know.
You're a hugger.
Again, I would go to the totality of the circumstances. I would argue it's a cultural norm to give hugs when you see a person that you know. So it would go to the totality of the circumstances. Does that answer your question? I'm a lawyer, so I always say kind of maybe, but. You're welcome. Thank you.
Well, and if I can just go ahead and add, obviously the safest course in any situation is getting verbal permission, as Ms. Epstein said. I guess, you know, it probably we're not always going to do that. And there's we communicate lots of different ways. We show affection lots of different ways. There's going to be all kinds of gray area situations. I don't see how that, I'm good, I'm getting a nod from our attorney, that's validating. I mean, so all we can do is keep reminding ourselves of this, try to use wisdom and discernment in interacting with people. I think it is a little bit, at least, incumbent on us, if we are uncomfortable with affection, to communicate that, at least, I mean, 'cause I do think communication goes both ways. And then just be aware that to the extent you're misreading a situation, you may be offending or harassing somebody. And just bear that in mind. Did I say anything wrong?
No, sir.
Excellent.
Did I? No, sir. There.
Mr. Bowers.
Thank you, Mr. Speaker. In the context of this meeting, Mr. Speaker, do you want us to rise?
No. Thank you for that question.
Thank you. Another little comment that you made, ma'am, is that you said a court would see this as, or a court could see this as, and I'm thinking that if I am thinking constantly, what would a court see this as, that could be inhibiting to the discourse, verbal, nonverbal, that I'm enmeshed in. I'm swimming in it. And I refer to your comments, Mr. Speaker. Yes, it takes discernment, but it takes it on all parts. And it takes tolerance on all parts as we move towards a greater understanding, yes, a greater correctability of one's actions, etc. And I am thankful that we're here, and I'm grateful that we can talk about it at least. So those are some thoughts I had. Thank you. I'm sorry.
Okay, thank you. So we left off at scenario 4. A male employee asks a female employee, "How is it you're as old as you are and not married yet?" Again, can sexual harassment also include age discrimination? That's a trick question. That would be 2 separate charges you would file: sex harassment and age discrimination. Some courts, some federal circuit courts have found that you can have a hostile work environment based on age. So it's a trick question. What if the conduct isn't just? Again, we look at how the person took it, and if a person in a reasonably situated situation would take that as offensive, then that could conduct a hostile work environment based on sex and age. What is the best practice? I would say just don't joke about people's age and whether or not they're married, personal statuses. So, pop quiz. A person has to say stop for the behavior to be unwelcome. True or false? Correct. I would point to a situation where a supervisor is harassing an employee, and they may not feel comfortable saying stop because of the economic relationship between the two. A male employee can ask a female employee out without committing sexual harassment. True or false? True. Again, we'd have to look to, does it become a daily request? Is it pervasive? Those sorts of things. True or false, people who fail to immediately bring a complaint of harassment waive any right to complain. Absolutely false. The EEOC requires 300 days to file a complaint. So once the discriminatory practice had occurred, they have 300 days, almost a full year, to 10 months to file a complaint. The Arizona Civil Rights Division, in which I work, has 6 months or 180 days to file a complaint. And I believe that Mr. Fleming is going to talk about the House policy and the timelines on that. True or false, a white male cannot be discriminated against because he is not in a protected category. False, he is in 2 protected categories, white and male. True or false, it is okay to exchange sexually explicit emails at work with those who you know who will not be offended. False, and I can think of a couple of reasons. First of all, I'm sure that you have an email policy in the House. I know that we do at the Attorney General's office, that we cannot exchange inappropriate emails that are not work-related. Secondarily, I would argue on this, if it wasn't a state environment and if you went to just a business environment, how do you know that the people aren't offended? Is it because they laugh it off? Is it because they don't respond and say that they're offended? So generally speaking, I would avoid discussing any sexually explicit items at work, and of course, not exchanging those emails. So let's look at what retaliation is and what is unlawful retaliation. The idea is is what happens to me if I complain? We look at a protected activity, if that was in place, an adverse action, and of course a connection or a nexus between the protected activity and the adverse action. What are protected activities under Title VII? Notifying a supervisor about workplace discrimination or harassment. And that can go to notifying a supervisor even if you aren't the person being harassed. So a person that is not being harassed can notify a supervisor about workplace harassment. If they get later on fired because they notified a supervisor, that is what we refer to as retaliation. Filing a charge of discrimination or a complaint either internally with the House or externally with the Arizona Civil Rights Division or the EEOC. Cooperating in a workplace investigation, either internal or external, are protected activities. So the concept of a protected activity is broader than just the areas of discrimination and harassment. It includes other workplace issues, such as reporting safety concerns and illegal activity that might be occurring. What are adverse actions? The law forbids unlawful retaliation when it comes to any aspect of employment. Hiring, firing, discipline, compensation, job assignments, transfers, promotions or demotions, layoffs, training, benefits, or what can be considered another term or condition of employment. So the connection here is unlawful retaliation occurs when there is an adverse action taken against an employee specifically because the employee engaged in a protected activity. So do you have to make a complaint to the EEOC? Again, you don't have to. You can go to House internal policy. If you do make a complaint, again, I said you have 300 days to do it with the EEOC and 180 days under the Arizona Civil Rights Act. Do you have to confront the harasser? No, but as we discussed, the conduct must be unwelcomed, and if you reciprocate the conduct, if a joke is made that involves sex and you make another joke about sex and you make a complaint, that may not be harassment because you reciprocated it. So if you do make a complaint with the EEOC or the Arizona Civil Rights Division, we do what is called intake, and that is, was a prima facie case of a discrimination had occurred, and then we provide that complaint to the employer, and the employer provides a response. Then both parties are invited to mediate to discuss what occurred and to try to come to a resolution. And if mediation fails or if the parties choose not to mediate, the case will go to an investigation, and the EEOC and the Arizona Civil Rights Division have broad power when doing interviews, requesting evidence, requesting text messages, emails, any sort of thing. We do have subpoena power. And then after the investigation is concluded, We'll provide preliminary findings, meaning whether or not a violation of the law had occurred. And if needed, we'll file a lawsuit. And then there's a trial and an appeal. So let's go over a couple more questions. True or false, an employee can let a supervisor know off the record that harassment is occurring. False. I heard falses. Correct. An employee, once a supervisor finds out that sexual harassment is occurring, that triggers a duty for that supervisor to take action, to do an investigation, to determine what is going on. So there's no off the record with supervisors. True or false, the person who's experiencing harassment is the only one who can complain about it. False. Correct. Any person who witnesses harassment can notify their supervisor or person in charge to say that harassment is occurring. And that is my last official slide. Are there any questions for me?
Mr. Bolding.
Thank you, Mr. Speaker. With regards to your last comment regarding the person who's experienced harassment and someone else complaining about it, does the individual who appears to be experiencing harassment have to consent for any type of investigation or something of that nature? Because I would imagine, I wouldn't know, but some people may not want to put themselves in a situation that another individual has then triggered in an investigation for them. So how does that work? Does it need to be a consent from on the party who an outside individual believed that they were harassed?
So are you asking regarding House policy or federal state law?
In common practice.
Okay, common practice is with the EEOC and the Arizona Civil Rights Division, we can file complaints without the harasser. However, we need evidence to back that up. So there needs to be, if the person harassed doesn't participate, then we need to have evidence to prove that they are being harassed. But there needs to be an aggrieved party. Does that make sense?
Yes, thank you.
Okay, thank you.
Mr. Lawrence.
I don't know whether you can comment on this or not. You gave a list of a delineation of the steps in the investigation of harassment. Where is the House or the Attorney General in those steps? Are they being followed in those cases presently before the Speaker and the Attorney General's office? Can you even comment on where those cases are in that list?
I may not comment.
I had such a long question, such a short answer.
I try to be concise.
Ms. Peaton.
Good morning. Thank you for taking my question. This goes back to page 115, and it is the examples of conduct, which are visual. And the first bullet, offensive posters, cartoons, pictures, etc. And my concern is when those types of things are posted deliberately in a public setting so that you can see them and you do find them to be offensive. For instance, if someone has a screensaver of the Confederate flag, given the history of African Americans in this country and particularly of late, of all of the controversy that has brought that to our awareness in the public eye, I consider it offensive when someone displays a Confederate flag on their screensaver. And for me, it's intimidating. It creates a hostile work environment, and it should not be allowed. If we don't allow the Confederate flag to be flown in the Capitol, it shouldn't be displayed on the floor. Thank you.
Ms. Carter.
I just have a quick clarifying question. So all of the information that we just went through is related to sexual harassment between either an employer and employee or employee to employee. Do the same rules apply, or is there any action that can be brought when you're talking about elected to elected or elected to lobbyists, because there isn't that employee relationship. So that's where I really would like to spend some additional time, and maybe that's going to come up in the rest of the presentation as well. But what we're talking about here isn't necessarily, I don't want to say it's not relevant, maybe the content of it can show what the actions are defined as, but what you're talking about in terms of bringing suit and bringing a complaint forward doesn't exist with what we've been hearing about here at the Capitol.
So my idea was to cover what unlawful conduct is under Title VII. I believe that what Mr. Fleming will discuss and what other presenters will discuss will actually tell you that the expectation is higher, and it's a no tolerance workplace harassment. So I think that what I provided to you, what is legal and illegal under Title VII, however, I think the standards are higher than that with internal issues.
So if I may ask a follow-up question, and or just cue up Mr. Fleming to maybe fill in the blanks here. Okay, then I will wait. Okay.
Mr. Lawrence?
With regard to what you might show on your screensaver that is offensive, I would find it offensive seeing NFL players kneeling when the Star-Spangled Banner is being played. So, equal offensive items.
Well, okay. I guess let me respond to the 2 points that were made. A lot, and this is what kind of threw me a bit on the page 115, where we talk about offensive. We use the word offensive 3 times. The problem is, to some degree, offensiveness or being offended is a choice, or will depend on a whole host of things. Down here, we get offended at each other all the time with comments that are made. There are certain people that really get under my skin, but not just Dr. Freese. But I mean, I'm just. That was in jest. Is that okay?
You have to ask him.
There's always a risk. So, I mean, is this just into that gray area? I mean, at what point is like someone's offended by something, but I have a right to do something, even if that person's offended by it? How does that work?
So I would go to number 1, totality of the circumstances, and look at that slide again. And then also, it has to be in jest and unwelcomed. And if a reasonable person in that situation is not, it would be a question, basically a question of fact for the jury. And they would have to find that not only was that person offended, but was a reasonable person similarly situated in that offended as well. So I'm not going to give legal advice, but I would just be very careful in a workplace environment.
But what about a political environment?
I can't answer those questions. I think that goes to the House policy, in which Mr. Fleming will describe.
Okay, Ms. Engel.
Mr. Speaker, I had a question from Ms. Browder. This is a follow-up to Representative Carter's question about, and I know we're going to talk separately with Mr. Fleming about the House standards, but I'm wondering if even under the Title VII law, there's some recognition for harassment, even economic harassment, which is not an official sort of employee-employer relationship. I mean, is there any recognition where somebody has some kind of control over the other person's job duties that might actually be analogous to what we have here, you know, the chairman of a committee or something over other people on the committee? So I'm just wondering, you know, what is the strength of the analogy to Title VII to maybe some of the things that we experience?
Title VII has to be based on a protected class. So you have to be discriminated against someone because of a protected class. And I don't think politics are included in Title VII. Does that make sense?
Is that true of economic harassment as well?
Under Title VII, it has to be based on a protected class. So, yes.
Okay, well, even within that confines, is there is there some, I guess, a little bit of flexibility or looseness about what is a supervisor, or it is, the supervisor is somebody who hires you?
There's a lot of case law on what a supervisor is, and it's not only whether or not a person hires you, it's a managerial responsibility. There's all sorts of things. I don't think it would, well, I can get back to you on that if I need to. I can look up some case law for you. But it doesn't include elected officials and those sorts of things.
Okay. Okay, thank you.
Okay. I'm trying not to be too qualifying, but.
Mr. Bowers?
I apologize, Mr. Speaker, but on page 115, the first bullet point, the second category, am I now being put under restrictions?
I don't know what the second.
He's an artist.
I'm smiling.
So that was rhetorical. Okay.
Ms. Carter, this isn't the classroom. You just press your button. You don't have to raise your hand.
The teacher in me keeps coming out. So I just want to be really clear here. Based upon what you just said, nothing that we are talking about is a tool that an elected versus an elected, in terms of any of the allegations. It was great to go through the description of what is and isn't harassment, but the rest of the story is, and so you bring action, and so you bring it to your employer and you file. None of that is even relevant to an elected versus elected, or a lobbyist to an elected, because there is no employee-employer relationship based upon either existing statute and or case law. Is that correct?
So I would say under Title VII, elected versus elected complaints are not covered. However, under House policy, they are, and Mr. Fleming and other members will go through. The purpose of my explanations were to describe what is and what is not lawful under Title VII and the Arizona Civil Rights Act. The House policy is much stronger than what I just went through, what is unlawful.
Well, I think at the very least, this is helpful for us to understand behavior, because that certainly then dovetails into the House policy. So to the extent that there are some processes that may not exactly apply, it applies to me. I mean, everybody in the building is technically under my hiring and firing. And then you all can have sort of a supervisor type role, which if I heard it right, could sort of apply to you, even if you can't necessarily fire them directly. Only I could do that. Still, you can be in a supervisor role, and this could apply, so for instance, to employees here, or, but you're right, so lobbyists, I mean, they don't work here, so we'll talk more about that when we get to the House policy. There were some other people that disappeared. Do they not have questions? I don't have anybody else up here. Okay. So that's all you got.
I've got one more slide, and of course it's of my twins. Thank you. I hope that my presentation was a little less traumatic than when my twins saw Santa. So that's all I have. Thank you for your time and attention.
Okay, before we get into the next segment here, I just want to take like a 2-minute break. Okay, let's just stand up, stretch, walk around, take a couple of moments. You got to use the restroom, do that, and then we'll jump into the next segment.